Hello, 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 you guys. We made it. It's Friday. The weekend's on the way. We have a long weekend because of Labor Day. Woohoo! Hi, everyone. How are you? I hope you guys are all doing super duper well. So, as you know, I had to change the title of my live because we were going to talk about Alex Murdaugh and the jurors. Well, then when I was looking at some things, I had a live that I wanted to do tonight regarding Sarah Boone because the math ain't mathin', y'all. A friend of the channel has gotten a hold of some things that I wanted to show you guys with regard to her former attorneys and some of the allegations that she made regarding how many times they visited her and all that kind of stuff. Sarah's math ain't mathin', and that's what I was looking at. Well, then because obviously in order for me to add, you have to read Sarah's letters, right? Because that's one thing Sarah Boone loves to do. She makes a whole list of how many times so-and-so came to visit her or talk to her, blah, 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 right? Okay. So then as I'm refreshing, boom, here it is. The breaking news. Let me share it with you guys. Please hold. Oh, wait, hold on. This is the wrong thing. Just a second. Let me scroll up. My bad. Ugh. Are you kidding me? Hold on a minute, you guys. Orange County has kicked me out. Sheesh. I'm not a robot. Oh, for Pete's sake. We're going to do this test really quickly. Talk amongst yourselves. I'll be right with you. All right. There we go. Okay. We're in. All right. Here we go. Hold on. Let me read this. Oh, we got a couple of new things. Un momentito, por favor. Okay, so let me close this and go here. All right, this one. All right, now I'm ready. My bad, you guys. All right, sorry about that. Okay, so there has been a motion to continue filed on behalf of Sarah Boone, and here, let's read. Let me get my reading voice on. All right, here you go. Here we go. Comes now the defendant by and through the undersigned attorney under Rule 3.90F of the Florida Rules of Criminal Procedure and requests this court to grant a continuance of the 3-week jury trial set to begin October 7th, 2024, and alleges 1. The defendant is set for trial by jury October 7th, 2024. 2. The defendant has just now retained defense counsel and a notice of appearance was filed Friday, August 30th, 2024. 38 days remain before trial. 4. Defense counsel has met with the defendant 4 times at the Orange County Jail, August 20th, 21st, 26th, and August 27th. During these meetings, the defendant disclosed potential exculpatory evidence on her phone in the possession of the Orange County Sheriff's Office. Evidence includes photographs, videotapes, calendars, text messages, notes, and witness names and numbers. This evidence will potentially corroborate her anticipated battered spouse syndrome defense under Rule 3.201 of the Florida Rules of Criminal Procedure. Undersigned counsel has spoken with numerous potential expert witnesses covering a range of possible defenses. Counsel is also actively vetting several additional experts upon directives from interested parties. 7. It is the professional opinion of counsel that the retention of one or more of these experts and the development of the aforementioned defenses is a crucial and necessary component of the defendant receiving full and competent representation and due process under the law. Based upon the conversations that have occurred, counsel has learned that proper diagnosis and development of said defenses requires time not only for administrating appropriate testing, but also the necessity that any expert testifying on behalf of the defendant be given adequate time to establish a trusting relationship and then be allowed to apply the analytical tools to the information developed from interviews with the defendant and supplemented with historical and documentary information from third parties. This process, as described to the undersigned counsel by renowned and respected experts, cannot be accomplished in the time available before trial, particularly given the JAC ministerial hurdles which must be cleared when dealing with an indigent defendant. Notice of intent to rely on the battered spouse defense syndrome must be filed 30 days before trial. The notice must be filed by September 7th, which is 8 days away. The defendant has now been deemed indigent for costs. The defense will need government funds to assist in paying the experts in this field. Defense motions will need to be filed concerning the potential Brady material. The defendant has the right to be represented by counsel of her choice. The defendant attempted to solicit private counsel after the court's order dated June 28, 2024. The defense counsel responded to her advertisement and was retained. So her advertisement was success. The defendant is not trying to delay the proceedings or abuse the process by retaining counsel at this late date. The defense certifies this motion is made in good faith. And then they cite the memorandum of law, which is the Sixth Amendment to the U.S. Constitution, and certificate of service. And the new attorney representing her is James Owens. Okay, so let's see here. Okay. All right, so as far as that goes, nothing new there as far as an answer from the judge, okay? But let me remind you guys of something. I don't know how this is going to go. And here is why. Because, let me scroll here to the order. Just a second. Here it is right here. Okay. So this is not the one that I wanted. Back when Judge Kranick wrote the order for the withdrawal, one of the things that was written in that order is that, and I wanted to get it because I want to make sure that I have it correct. And I don't understand why I'm having such an issue finding the actual order, because I know when it was written. So maybe it's this. Yeah, I bet this is what it is. Okay, hold on. It's her motion to withdraw. And it's way down here. So just give me just a second to get it. Okay, hold on. I know there's more. Where he specifically expressed continuance. All right, so let me just do this. Let me do. Okay, there's 4 of them. So let's go. Let me find. Okay, that's not going to help me. Hold on. Give me just a second, you guys. I'm sorry. This is all new and I didn't have like a ton of time to prepare. And I don't like for there to be like, nobody speaking, but it's going to take me just a second to find this specifically because I want to make sure that I get this correct. Because I remember him saying that, here it is. This case shall remain specially set for trial for the 2-week trial period beginning Monday, October 7th, 2024, and will not be continued for any reason except by extraordinarily good cause. And such extraordinarily good cause shall not include retention of counsel by the defendant. So there it is. I wanted to find that. Sorry, you guys. Happy birthday, Bernice. So yeah, I'm not exactly sure how this is going to play out because retention of counsel, as in that order of 6/28/2024, does not allow for her to just because she retains an attorney does not mean that she gets a an extension, a continuance. They want to get it done. Carolina, she will be going to trial. This is what is in question, okay? What is in question is it's not whether or not she's going to go to trial. She's going to trial. They're preparing her defense. That's why she has an attorney, okay? This attorney is motioned for a continuance in an effort to be able to interview and have expert witnesses meet with Sarah. They want to get a hold of her phone because Sarah claims there's potential exculpatory evidence on that phone, which here's the thing about that. Let's just break this. Let's do this. Okay. Let me just harness my chi and let's go through each one of these numbered motions or reasons for filing for a continuance one at a time and break them down. I think that will be the easiest way. Definitely, it will be the easiest way for my brain. Okay, so let's start at the beginning now that I've read it to you guys, and let's talk about it. This is pretty self-explanatory. 1 and 2. We know that her trial is set for a jury trial October 7th. This has been filed today, August 30th, 2024. Yes, there are 38 days before the trial. This other one, self-explanatory, that the defense counsels met with the defendant. Okay, so let's talk about number 5. During these meetings, the defendant disclosed potential exculpatory evidence on her phone in the possession of the Orange County Sheriff's Office. Evidence includes photographs, videotapes, calendars, text messages, notes, and witness names and numbers. This evidence will potentially corroborate her anticipated battered spouse syndrome defense under this rule of the Florida Rules of Criminal Procedure. Okay, let's talk about that. When Sarah's phone was taken into evidence by the state of Florida, okay, by Orange County Sheriff's Department, they did a download of her phone, okay? They used Cellbrite and they extracted her phone, okay? When they did that, it's a complete download of the phone. Now, I'm not 100% sure, so I don't want to speak to this part of it because I'm not 100% sure. But I don't know if they download the contacts. That I don't know, because usually when the Cellbrite report is presented at trial, it usually only covers like text messages, Google searches, stuff like that. Okay, videos that might be on the phone, etc. All right, it doesn't. I haven't ever really heard testimony of a contact list, so I'm not 100% sure if it downloads a contact list or not. I will look into it, and hopefully, I can have that answer for you guys. Okay, so I don't think that the judge is going to be moved by number 5, because Sarah was given her discovery. Okay. So that included on those thumb drives, those the downloads from of her phone from Cellbrite. Okay. The extraction. So I don't know that the judge is necessarily going to be moved by this, because the judge can very easily say, well, you've met with her 4 times, and in those 4 times, did she give you the thumb drives? Or why hasn't there been a motion for you to be given that from the jail? Okay. So and again, I want you guys to also, let me state this very clearly as well. I am not an attorney. So these are just my thoughts based on what I'm reading in this motion and what the judge has said previously. So please, please don't take this with a grain of salt. You better get a truckload of salt, okay, like a whole storage room of salt, because I'm not an attorney. She can get the iPhone, and they can have their own expert witness extract the phone. But that's the only way that it's under certain conditions, because she specifically, in other hearings that have come before the judge, when they talked about the physical evidence, which is the phone is part of the physical evidence, that was addressed. And there are only certain ways in which the state will allow the phone to be turned on, because once the phone is turned on, obviously, then then new information can come in, so that's why. Okay. And so I think basically what all that needs to happen with this phone situation is there just needs to be a motion filed. And I don't even know if there needs to be a motion filed. The fact of the matter So, there's a couple of things that need to happen also. And let me get this back up here. Hold on. Let me share the thing again. Can everybody hear me okay? I'm sorry, you guys. StreamYard's been messing up for everybody. I'm not on Wi-Fi. I'm plugged right into the router. It's a StreamYard issue, not a Genlu issue. Okay. So let me add this back to the stage. So we're on number 5, okay? Number 5 is basically about the phone, all right? So there's I want to talk about a couple of different things because I got something has occurred to me while I was messing with all of this that I didn't discuss, but I want to finish what we were talking about with respect to the phone. Okay. I don't think that the judge is going to be particularly moved by number 5, which is because, there's potentially exculpatory evidence on the phone, because at the end of the day, Sarah has the download of her phone and it is her discovery. And I don't even know that he needs to file a motion with the court in order to be able to give her, it's her discovery. She can do what she wants with it. So if her intentions are to give it all over to her new attorney that she has quote unquote retained, which I'm not sure how she has retained an attorney and yet is also filing as indigent. I don't know how this attorney expects to get reimbursed. See, this is a little bit of a conundrum, and because I'm not an attorney, I don't really have all of the answers, but I will tell you this. I can guarantee you that that LawTube, i.e. the lawyer and others that are part of that community, have already seen this and are probably making a video about this right now. And they will definitely have the answers. And of course, I will watch, and of course, I will tell you guys what they said and, what they think. Okay. So that's number 5. I don't think that's going to get her anywhere. Now, one thing that is missing from this filing is essentially the notice of attorney of record. See, in order for you to be recognized as the attorney, right, for a defendant, you have to file a motion essentially announcing, hey, I am now representing this person. In this case, it would be Sarah Boone, right? And, that's the deal. So he hasn't filed that he is now the attorney of record, which, see, this is the other thing that causes a little bit of a calamity. To the state, Sarah Boone is pro se, which means they can speak to her. Okay. However, when you retain an attorney, whether that is through the public defender and your attorney is appointed, or you actually, I shouldn't say retain, when you are represented by an attorney, whether that means that the public defender's office has been appointed and you're represented by them, by attorney, with the public defender, or you've retained private counsel. Either way, there needs to be notice that you're represented by an attorney. And so far that hasn't been filed. Does that mean it doesn't exist? No, it just means it hasn't been put on the website, okay, on the clerk's website. So it's possible that the attorney has done that and it just hasn't been uploaded. I'm not sure. Okay. Now, let's see. What's number 6? Okay. Undersigned counsel has spoken with numerous potential expert witnesses covering a range of possible defenses. Counsel is also actively vetting several additional experts upon directives from interested parties. It is the professional opinion of counsel that the retention of one or more of these experts and the development of the aforementioned defenses is a crucial and necessary component of the defendant receiving full and competent representation representation and due process under the law. Okay. Well, back in the day, whenever Sarah was representing herself, she filed a motion, and her motion was to get money from the JAC for an expert witness, and she cited a very specific expert witness. And the ruling on that was that the JAC, while they weren't 100% on board with it, because so much money has gone out by and through other attorneys representing Sarah and requesting funds for expert witnesses, they've paid out. They were not going to request a hearing about this. They were going to defer to the judge and allow the judge to make the determination. Okay. So do I think that the judge is going to be moved by that? I don't know, honestly. I mean, that is a compelling argument, and it's an argument that Sarah probably would have come across herself, right? If she had read through the JAC packet for a pro se defendant that she was given. The fact of the matter is, once you are allowed, once the funds are released, as it were, you still have to meet with the expert witness. You have to be evaluated by the expert witness. And then also, the expert witness has to have time to generate their report, right? But also, on the other side of that, the state also gets an opportunity to send in their expert to do exactly the same thing. And that takes a little bit of time. So it's quite possible that he may be moved about this by these arguments. It's possible that he will be moved by these arguments. Let's see, which is basically what 8 and 9 talk about. Now, number 12, defense motions will need to be filed concerning the potential Brady material. Do I think he will be moved by that? No. Here's why. Because there was a deadline for that anyway. Okay. So the judge and the state and Sarah had all agreed that there was to be a viewing of the physical evidence prior to September 3rd. Okay. Because Sarah had filed a motion orally, it wasn't filed. She had given a motion orally objecting to the media being allowed at a hearing in open court where she would be viewing the physical evidence in her case. She lost that motion. The media won their motion. The state took no position. They didn't care. So they had made an agreement, the state and Sarah, that Sarah would be allowed to go and view it at the Orange County Sheriff's Department or Sheriff's Office. And it was to be done before September 3rd. And the state was to file that it had happened and that, all of that, right? So after that takes place, then Sarah was given 2 weeks from that time to file any objections regarding that evidence. So if she doesn't want certain evidence to be in there and she objects it to being admitted against her at her trial, she needed to file that. Of course, you have to give a reason, and then there would have been a hearing, right? The judge would have listened to the state, the judge would have listened to Sarah, and then made a decision about each piece of evidence that she objected to. So that was already supposed to take place. And that has, so I don't think that is going to be a compelling argument on the judge to the judge for a motion to continue. The defendant has the right to be represented by a counsel of her choice. The defendant attempted to solicit private counsel after the court's order dated June 28th, 2024. The defense counsel responded to her advertisement and was retained. Okay, see, this is going to be where it's a little bit tricky, okay? When were you retained? Because, again, if you read the advertisement, then you are also aware that the stipulation the judge gave was that there would be no continuances granted unless under extraordinary circumstances. And retaining an attorney is the court ruled was not going to fall under extraordinary circumstances. It wasn't going to be a good enough reason. So I don't think that he's particularly going to be moved by this argument at all. All right. And that's about the end of it. The defendant is not trying to delay the proceedings or abuse the process by retaining counsel at this late date. Well, I don't really know what I think what's going to happen is there's going to be a hearing. I think that let me look at something really quick. This is that there's more jail reports too that I want to read to you guys. So there's a hearing that's scheduled September 3rd. I think what's going to happen in that hearing on September 3rd in front of the judge is going to be all of this. Let me see what this is. Oh. These are more jail records. Hold on, let me see something. Yeah, this is the same thing. All right. Okay. I don't know. Honestly. Get Me a Snack says, so does she now have to turn over all the discovery she has at the jail? Okay. I think that the judge is going to say, well, turn it over to your attorney. Why are we wasting time with all of this business of, exculpatory evidence when you don't need time to, you don't need time to get the exculpatory evidence. If there is I should use that word, potentially exculpatory evidence, you don't need to take that time. If there's any potentially exculpatory evidence, she's got her entire discovery. Have her turn that over to you. It's possible that they could have a hearing today, although it's not on the docket. Let me refresh, because these things get updated moment by moment, and there isn't anything new. Nothing has changed. I don't know what's going to happen, to be quite honest with you. I just don't. I think that the judges might be moved by Boone's attorney needing time to get expert witnesses. I think that if Sarah herself had filed for a continuance for expert witnesses, he may have been moved by that. Like I think what it's going to take is this. Hold on, let me say something really quick. Thank you, B Crumbs, for gifting 5 memberships. If you guys got a membership due to the lovely B Crumbs gift, be sure and thank her. And also, thank you, B Crumbs, for being a member for 14 months. I appreciate the support. So oh gosh, let me think about this for a minute. I think, okay, so if Sarah herself, let's say there was no attorney, and Sarah herself filed a continuance for an expert witness, I think the judge would be moved if the reason for the continuance was due to the expert witness's schedule, meaning Sarah retained them as an expert witness. They had agreed to be an expert witness for her. However, they have their schedule is booked up and it's going to take time. It's going to be a minute before they have the free time or a free space to go and visit with Sarah in the jail, interview her, evaluate her, do whatever it is they need to do, right? Then write a report. And then conversely, the state would need time to do the same. So do I think that the judge would would grant a motion for continuance based on that? I do. Okay. But again, he's going to need or want to see, in my opinion anyway, because he's been very firm about this, that he's going to need to see, these are the witnesses that we intend to use. This is their schedule. This is when they come. And the state is going to have to agree, hey, yeah, we are going to need a little bit of time because we want to get somebody in there to evaluate her as well. However, based on her filings, right, that she filed pro se, asking for an expert witness, and it was a neuropsychologist is who she asked for, the state has an idea of what she's trying to do. And so they probably have an expert witness ready to interview her whenever, the schedule allows. So, I feel like I do think that the expert witness situation may get a continuance, but I don't think, let me check again to see how long they're asking for of a continuance. Let me see. This is kind of confusing. To grant a continuance of the 3-week jury trial. See, okay, this doesn't sound like they're asking for 3 weeks, because the judge, when he set time for the trial, he allotted 3 weeks for the trial. So there's nothing in here that I'm reading that says, hey, I need X amount of time. Let me see. This is interesting. The matter of continuance is traditionally within the sound discretion of the trial judge, and it is not every denial of a request for more time that violates due process, even if the party fails to offer evidence or is compelled to defend without counsel. Contrariwise, a myopic insistence upon expeditiousness, look at that word, in the justifiable request for delay can render the right to defend with counsel an empty formality. The right to counsel, or the right to assistance of counsel, not only reaches the trial stage, but it extends to sentencing as well. Further, the Supreme Court has stated that implicit in this right to counsel is the notion of adequate time for counsel to prepare the defense. It's not asking for so this is probably something that will be argued in front of the judge. And I think that the judge is going to, I think the judge is going to grant a continuance. And I think that likely what will happen is the defense will ask for a specific amount of time, and the state will probably give a suggestion. And I think the judge is going to meet somewhere in the middle, because you don't you don't want your rulings as a trial judge overturned on appeal, right? And you definitely, want to err on the side of caution, right? You don't want to do anything that Sarah is afforded the right to due process under the law and all those things. So, you don't want to do anything to take away her due process. But at the same time, this has been going on for quite some time. And the fact of the matter is that Sarah brought all of this on herself with her letters. And we've talked about this many, many times on this channel. The truth is, even if Sarah doesn't implicitly state in these exact words, I don't want X attorney representing me, her the letters that she wrote to the court, where she tells the judge that these attorneys are not up to snuff, they're not doing what she wants, she has no trust in them, no faith in them. She called all of them incompetent at one point or another. I think when you are referring to your counsel as incompetent, I think that it is implied that you don't want them to represent you. Why would you want somebody who's incompetent representing you? We've had this discussion like ad nauseum. So and this is another situation, and this is an excellent, excellent question. Jennifer Mills says, what if this attorney walks next week? And this is something that's going to be in the back of the judge's head, because this is not the first private attorney that Sarah Boone has retained. Mr. Padilla was a privately retained attorney, although it changed from him being privately funded to Sarah being declared indigent and then the JAC reimbursing him. Okay. So this is also a problem. Because what those attorneys all essentially said in their motions to withdraw is that part of the reason that they wanted to withdraw was regarding ethics. And to me, that sounds like something more serious than just Sarah has a negative attitude. She doesn't let a smile be her umbrella, and she's difficult to work with. That sounds like something more serious than a personality conflict. That sounds like she wants a defense that is unethical, that they can't do. And I think that the judge is definitely going to take that into consideration. I think that he has to be mindful of that. And there's a lot of potential stickiness in this. So, yeah. Okay, so now let's go over here to these new, this one. Let me scroll up. There's more jail reports. So let me stop sharing this screen and let me share. I think this one is the one I want. Hold on, let me look. Yes, okay. All right, let me add it to the stream. All righty. All right, so this is an officer contact note dated 8/19/2024 at 1:43 a.m. and created at 2:05. Yeah. All right. Let me make this a little bigger, easier on my old ojos. Inmate Sarah Boone is currently pro se and is allowed a laptop per scheduled hours of the day. Inmate Sarah Boone currently, okay. The laptop had a low battery and needed to be charged. An entry was made hours ago by this officer. This seems like the same thing we already read. Hold on. Let me keep looking. Oh, no. No. This is similar. While collecting the form, inmate Boone, I informed her that the laptop is now charged and should be ready for use in the morning. I told her that I will make the day shift officer aware. We did already read this. That's when she took the form back. Okay. And then we have her refusing breakfast. Evening shower was available and offered. Sarah Boone verbally refused evening shower. Let's see. This is more about her laptop and charging stuff. And let's see. Corporal Pagan and I engage in a discussion with inmate Boone in the FDC briefing room regarding several matters. We address the proper channels for submitting request forms, emphasizing that they should be directed to the housing officer or shift supervisor. These, I have to say, are reminiscent of Letitia Stout, who never addressed her issues with the right people at the right time using the right channels, and yet still claimed that everybody was against her. Anywho, I digress. That they should be directed to the housing officer or shift supervisor rather than to county legal counsel Scott Chevenel and Captain Giovanni for routine needs. Okay, so basically what's happening is Sarah has issues, she's got complaints, and she has completely skipped the chain of command and is now wanting to speak directly to the supervisor. She's not even wanting to speak to employees. No, she's escalated the call directly to supervisors. Yikes, some bikes, Sarah. All right, action taken. Inmate Boone, who has been incarcerated since 2020, is already well acquainted with the established procedures and confirmed her understanding of them. Inmate Boone expressed a desire to have a tablet available for her to use throughout the day. Action taken. We clarified that tablets are accessible to all inmates on a standard schedule 7 days a week, ensuring reasonable access without the need for further action. The inmate also requested that writing materials such as pen and paper be replenished as necessary. Okay. Request denied at my level and escalated to the appropriate authority who provided guidance in compliance with our policies. Inmate Boone was directed to request our items via inmate request forms to the Law Library Department. No further action required. Note: Inmate Boone demonstrated a willingness to engage during our dialogue. However, she consistently paraphrased my statements while introducing details that were neither mentioned nor implied. Surprise! That's Sarah's wheelhouse. That's her brand. Consequently, I concluded the conversation and dismissed inmate Boone back to her unit due to her patronizing tone. Imagine that. And her persistent misrepresentation of my remarks and the information I aim to communicate. Ultimately, inmate Boone expressed her disagreement with my stance and decision-making, indicating her intention to file a motion with the judge to her assigned case. That's very on brand for Sarah. Constantly citing miscommunication, unwillingness to communicate, etc., etc. However, when she's communicated with, she does, we've watched it, we've witnessed it in court where something is said to her and she completely misrepresents what was just told to her. For example, the judge asking her a very simple, direct question: who at the jail did you speak to? She said she didn't know. And she said, and then he said, was it Hall? And she said, no. And then she says, it was Hall, but I don't know who sent her. Well, that wasn't asked. Just who did you actually speak to at the jail? So there you go. That's right on brand for Sarah Boone. Okay. Let's see. At 2000, inmate Boone was issued a tablet, laptop, 3 USB, 1 hard drive cord, one small size clear for USB, 1 medium size clear bag for hard drive. Let's see. Also on 8:20 at 9:35 p.m. The shower was made available and offered, and Sarah said, "No, thank you. I don't want to take a shower." So now we're up to 2 days, no shower. Let's see. The laptop was nothing there. This is all about her USB and all that stuff. Yep. Nothing else here of interest. That's the last page. So basically, nothing really new or exciting there. It's just, when you hear something in court and you have like your own take on it, and it's me, not you guys, me. Like when I watch Sarah in court and I hear, I see hear and see how she interacts with other people, other human beings, and I make commentary on that, on my impressions. It's my opinion that Sarah Boone, frankly, just doesn't people well. And, I feel like, I feel like when it's actually documented in a report like this, I feel a little bit of validation that I'm just not being mean, and I'm not just, just being, rude for no reason. Like this is, yeah. Nay, I don't understand the refusal of a shower for me personally. Obviously, it's not an ideal situation, right? I wouldn't want to take a shower with, a bunch of other people. I'm just, it is what it is. However, Sarah has been in jail since 2020. It is now 2024. Okay. I think at this point, I think if it were me personally, acceptance of your situation takes over. And you have to recognize that this is where you are. And if you want to shower, this is what you have to do. And even as stubborn as I can be at times, I think I know that my aversion to showers in jail with a bunch of people. I think the need to be clean would outweigh my aversion to take a shower in front of God and everybody. Okay, I would feel very exposed, but it is what it is. I would rather wash and be clean. It would just overrule. Yeah, I know, Lil Red. Aren't you shocked that I'm stubborn? It's woo. Yeah. So, yes, it is. Yes. Okay. So Nay says, but not doing isn't helping anyone get what they want, is what I'm saying. And it's the first thing they all do when they start pitching an entitled fit. Yes. The first thing they say is when they don't get their way is, I'm not going to shower. Okay. Like as if that's some sort of leverage. I don't understand that either. Maybe I don't understand how it works in jail, but I don't see that as a viable form of leverage. I mean, you're going to stink, okay, and you're punishing yourself and everybody around. See, I feel like leverage doesn't. It's a bit like cutting your nose off to spite your face, right? If you true leverage shouldn't impact you negatively, it should impact others around you negatively, right? If you have to suffer, it hardly seems worth it. That's just my opinion. Maybe I don't understand leverage correctly, or maybe I do and Sarah doesn't. Who knows? But yeah, I'm going to go back over to Orange County just to see if anything has happened in the last 4.5 minutes since I refreshed the last time. I just need to see how this is all going to play out. Like, don't you guys feel at this point, and I don't really like to use this word, but we've followed this case for so long that I almost feel like, dadgummit, we're a little bit, kind of entitled to see how all of this is going to end. I need to see how all of this is going to end. And now all of a sudden, some attorney, no, there's nothing. Some attorney has said, oh, hey, I've decided I'm going to file and let Sarah. I'm gonna represent Sarah. I've decided, that this is a fantastic idea, and I think that despite all these other attorneys, now I want to be clear about this. I'm not counting the motions to withdraw from the attorneys who had a conflict. That's different. That shouldn't go against Sarah. But we've got Padilla. That was the first one. We've got Frank Bankowitz, who tried to withdraw twice. We've got Mr. Hobson, and we've got Miss Cashman. So the other attorneys withdrew. Her first public defender withdrew because she wanted to retain private counsel. That's number one. And then there are three other attorneys, making four total, withdrew because of a conflict. Okay, so those shouldn't go against Sarah Boone. But when you have had 8 attorneys and 50% of them withdrew because of a conflict between themselves and the client, and the other 50% withdrew because of, like a conflict in actually representing them, actually representing the client. They couldn't represent her because of they'd represented either George or somebody relative to this case. I mean, for me personally, that seems like super judgy, or like a super bad judgment call. I mean, I know that attorneys, they take an oath, and I do respect the oath that they take, because particularly defense attorneys, criminal defense attorneys, because when you take that oath, despite how you may feel about a defendant personally or their crime personally, you took an oath to give them a vigorous defense that they're entitled to under the Constitution of not only the state that you represent, but of the United States of America. And that's a big deal. And it's serious. And I admire that. But my concern is Sarah and her brand, if you will, the way that she acts, how demanding she is, and all of those things. What if the judge says, all right, I'm going to grant you an extension. We'll make the trial, rather than be set for October 7th, we'll give you a month extra. We'll grant the continuance till November 7th. Now, I'm just using that date because it's 30 days. I don't actually know what day of the week November 7th falls on, but you take my meaning. That is now 60 days of working with Sarah. And what's going to happen if, when they get their expert witness in there and they evaluate Sarah, and Sarah doesn't care for the expert witness and is uncooperative, that comes out. That's part of it, So I don't know. As an attorney, I feel like I admire the fact that he wants to represent her because he feels like she deserves representation. I feel like essentially the judge is going to say something in legal terms that amounts to, bruh, I'm going to grant it, but you stuck with her. That's what I think is going to happen. So anyway, that's kind of all that I had for you guys today. Now, tonight, I do fully intend on discussing more with Sarah with respect to just how much time did these attorneys actually spend with Sarah versus what did Sarah put in her, in her letters, because I think that there is something amiss there. And so I want to talk about that with you guys. And also I want to talk to you guys about, this is Jersey. That was my intention for today for Lunch with Lou. But then obviously Sarah Boone, and I've been following her case forever and a day, and I'm invested in seeing the outcome. So of course I changed it. This juror is a juror that was actually part of the deliberations, where juror number 785 was not. She was dismissed prior to deliberations. And she had some interesting things to say in an interview that she gave. This is like her second interview. She interviewed with Court TV, and I think the first interview was with juror 785 on a Fox show. Fox News show. So anyway, I wanted to talk to you guys about that. So there is a bit of a scheduling. I will figure it out. I'll squeeze it all in. I don't care what it takes. But and then don't forget also, I think what I'm going to end up doing is, like you guys wanted, there are three, I put up a poll to who I'm going to roast. These are the top 3 suggestions for the roast on Sunday that is for charity. And I think what I'm going to do is, no matter who it is that gets picked, I do want to make the stream for St. Jude, and here's why. As many of you guys know, some of you might not. My granddaughter Olivia has interstitial lung disease, and it is a terminal diagnosis. But it's it's one of those diseases that the slower it progresses, obviously, the longer she lives. But I know that St. Jude's is a research hospital, and they do all kinds of research on all kinds of diseases that affect children. And so regardless of who we roast or how we do it or what what it is, that's who the first charity stream is going to be. It will go to benefit St. Jude. St. Jude. Sorry, I'm having a hard time reading. St. Jude. And the other thing is, since I'm going to be doing a roast casserole, if you would do me a favor on that poll, in the comment section, if you would drop specific like interviews, interrogations, phone calls, etc., that you would like me to include in the roast casserole, that would be very, very helpful. So I would appreciate that very, very much. Anyway, that's kind of all I had. So I guess what I'm going to do is play the outro for everybody and wish you guys a great rest of your Friday afternoon. And I will see you this evening. And we'll talk more about Sarah Boone. Maybe there will be an update. But either way, whatever happens tonight is Boone, period. I will either be discussing the lawyer situation, like the ex-lawyers, which are all things that the judge is going to take into consideration with this filing as well. I'm sure of it. So anyway, we'll be discussing Boone tonight. Thank you guys so much for being here. I appreciate your support so very much. If you haven't done so, be sure to give your Gabriel a thumbs up or thumbs down, either way, on the stream. Thank you guys. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious intent or effort was towards this.
No malicious.
It's on the 2 minutes later.
We all do a little mad sometimes.
And you know this, man.